good afternoon and welcome to another edition of John's Rants. I'm John Giardinelli, the association's attorney, and today's topic is kind of a potpourri of some issues, but we're going to call it Playing Nice with Others, how to stay out of trouble and what to do if you get into trouble. Some of the services that are available to you as members of the association. First of all, we're going to zero in on a couple of key issues that seem to come up a lot. That is the duty to cooperate with each other. It is an issue that causes a lot of difficulty. We hear a lot of complaints. So I want to kind of cover a couple of articles, revisit a few standards of practice, and then kind of go into what's going to happen. First of all, I want you to remember, your clients are watching. And so if you put yourself first, not your client, if you're not honest, client's going to feed off of that. The trends are to hold realtors to a very high standard. Your code of ethics automatically holds you to a very high standard, and of course, you have an obligation to comply. We don't know what the future is going to hold, but based upon the kinds of trends we're seeing from both the California legislature and the courts, as well as from the Department of Real Estate, I believe that, if anything, the standards and the manner in which you're to conduct yourselves will hopefully lead us to a situation where realtors can concentrate on the critical issues of dealing with property sales and not dealing with each other's misbehavior. So, remind you about Article 1. Article 1 is a very important article. It basically says that you are to hold your client's interest primary. Doesn't mean that you don't have any interest. It simply means that your clients come first. It's no different than a lawyer or a doctor. We put the people that we are serving before our own self-interest. The secondary duty is a duty you have to someone you're not representing, but it's part of the transaction, and that's to be honest. And frankly, it's a duty that I hear a lot of concerns about. Article 3 of the Code of Ethics is specific to this issue. It says you shall cooperate with other brokers unless it is not in your client's best interest. Not that it's not in your best interest, because maybe you won't make as much money or you'll have to split commission or something else, but it's in your client's best interest. And so if you're not cooperating with another agent because your goal is to try and get more money, or you're just simply not willing to share information, or you're the type of person that doesn't feel that they need to basically be nice, basically be professional, you're going to get yourself into some trouble. Article 2 of the Code of Ethics, while it doesn't specifically deal with cooperation or honesty, with cooperation or with failure to share information, does deal with exaggeration and misrepresentation. And so you need to be very careful that you're avoiding anything that could appear to be an exaggeration or a misstatement, misrepresentation, or that you're concealing information from either your client or from another party or the other agent. Even Article 12. Now, Article 12 is an advertising article, but it highlights once again what is held to be the national standard, which is that you have a duty to be truthful in all of your communications that are related to your real estate practice, including your advertising. You're not to misrepresent the availability of a property for showing. By implication, you are to return phone calls, respond to text, and that in a reasonable manner. That doesn't mean that if someone's being rude to you or behaves or is misrepresenting something that you have to tolerate that, but there's the right way and the wrong way to do that. You're going to disclose all accepted offers. That's Article 3, Standard Practice 3.6, and you're to act and disclose all of the things that you're required to disclose as part of your duties to when you respond to inquiries from buyers and sellers. Again, Article 9 says not only are you to disclose, cooperate, not lie, be honest, but also to put everything related to an agreement, whether it's an agreement between you and your client or an agreement between the seller and the purchaser, whatever that, or an agreement simply between you and another real estate office, but all those agreements in writing. particularly if they affect the client. And then lastly, there's a new standard of practice, which is standard practice 1-7, which says that you are to respond in writing when asked in writing affirmatively that your offer has been presented to the seller. Now, a sidelight to this is because of cybercrime issues, you need to be careful about how you respond. You need to be careful that if you're going to put anything in writing, that you not compromise people's emails, that you protect all of the information, particularly financial information, and that you be careful of things that are alleged to be non-deliverable and all of that. So what's going to happen if you're accused? Well, the most likely way that you're going to have someone file a claim against you is through the multiple listing service. So there's a couple of rules I want to remind you about. Number one is 7.8, that you have a duty under the multiple listing service rules to submit all offers and all listings, all listings within 2 business days after you receive them, or that you submit some type of an exclusion that indicates that your client does not want that property in the multiple listing service. And then, of course, if you fail to do that, you could be cited, and it's going to be up to you to explain why you failed to do that. Rule 9.3 is kind of important. It says that you cannot mislead someone about the availability to show the property or to have the property inspected. You're not to misrepresent the availability of the access to the property. And in fact, in the purchase agreement, there's some very specific contractual obligations to keep the property available for those inspections. You're to respond to all inquiries, and by implication, if you indicate that the property is not available, you may be holding yourself out for a misrepresentation claim. So there's an awful lot that can go on in the MLS rules. And then, of course, if the multiple listing service comes after you for a citation and you don't take the steps that they're requiring you to take, it could end up with a substantial fine, in many cases as high as $1,500, and in some cases even more. So another thing that could happen, of course, is someone could file a claim against you for ethical or MLS breaches at the board itself, in which case you will go through both the grievance committee process and professional standards. So a couple of things to be aware of that you might be able to deal with some of these issues if you don't think you've done something wrong or things are affecting your client's ability to sell or purchase a property. First of all, understand that the association has a phenomenal mediation program, number one. So if there's a dispute going on between you and your client, or even you and another realtor, then regarding a failure to communicate, there is a mediation service here at the association that would be available to you at a very reasonable cost. The association will provide you with access to other brokers who are experienced in handling these matters, in some cases even an attorney who can act as a mediator to try and get the parties to settle whatever disputes there are. It's cost effective, certainly when you consider the alternatives of arbitration or litigation, or even going before a tribunal regarding some of the disputes we're talking about. It makes very good sense. And keep in mind that these mediation services also meet the standards in both the listing agreements and in the RPA for mediation, which is mandatory in both of those documents if the circumstances call for it. Another service that's unique to the association is the Rapid Ethics Delivery Program, otherwise lovingly referred to as RED. It provides for very fast resolution of situations that might come up. For example, let's say you send an offer to an agent and you ask her to respond in writing confirming that she has presented that offer to the seller, and then you don't hear from her. You could contact the association. The association will intervene, call the agent, maybe even the broker, and in a lot of the cases, get the matter resolved. There's no cost. It's done quickly, and it provides that no one gets penalized as long as the problem is resolved. It's not formal. It's primarily anonymous, although obviously there are circumstances where someone would know who made the call. If you have evidence, for example, in my scenario, if you have an offer and you have a written letter, you should present that to the board with your concern. I will tell you that this is unique to the association. It has gotten national attention. According to the administrators, they're averaging at least 20 calls a week of this type, and 90% of those calls are resulting in a quick resolution and the end of the hostilities. So a great way to avoid a lot of expense, maybe seeing a deal go down the drain, and again, it's inexpensive and it's effective. If you do the math, 20 calls a week is over 1,000 calls a year, and that means 900 of those 1,000 calls have ended up in a resolution. The others will go to either grievance or some other process for resolution. If you're accused of a violation or you need some help in moving forward with a violation, the association also offers a kind of a unique program. It's approved by both the National and State Association, and it's called the Ethics Advocate Program. These are highly trained members of professional standards. It's a subcommittee of the hearing officers. They are specially trained, and they can actually represent you at no cost. They can help you prepare a complaint, respond to a complaint, prepare if you have to go to a hearing, either to present your case or to defend your case. It can even provide for situations where you would have to go to the board of directors in order to defend yourself from something such as suspension or expulsion. It's not available for arbitrations of monetary disputes. It's available for any ethics or MLS rule violation that would come before the association. And again, very effective. Sometimes if you've never been before the board, if you've never had a hearing before, you're not aware of all the rules. These people are trained. They know the rules. They know how to prepare a complaint. They know how to respond to a complaint. They know what evidence is important. While they're not necessarily lawyers, it's free. And so if you can't afford your own attorney, this is a great way to get very competent, very peer-oriented representation. So again, a lot going on. Try to resolve these problems amongst yourselves. First of all, remember, I didn't hire you to sell my house because I want to see you earn a commission. I didn't hire you to find me a house because I want to see you earn a commission. I want to get my property sold. You've told me you're going to put it in the MLS and offer it to a number of people. This association belongs to CRMLS, which is the largest association of its kind, MLS of its kind in the nation. And so you're basically telling me you're going to submit my property to 90,000 people plus, and that makes me feel like there's a good chance someone's going to take an interest, show my property to a prospective purchaser. If you're not cooperating, if you're interfering, if you're doing something like that, you're not discharging your responsibilities to me. If a problem does come up, the association provides services to try and get early, quick resolution. Sometimes people get stubborn. Sometimes people don't think they've done anything wrong when, in fact, they have. This gives you an opportunity to resolve those problems without any further exposure, cost, and in many cases can actually save your deal or prevent some other type of a hearing. So there's that. There's also mediation when you can't settle your disputes in an informal way. There's always the opportunity to settle financial disputes, especially with a mediation service that's really inexpensive compared to the more expensive services that are out there by thousands of dollars, and you're going to get quality mediators. All have been trained, quality lawyers, and you can get your case settled for very little money. If you do get brought into a case, or you feel you need to file a case, we have ethics advocates that can help you. They can show you the ropes, so to speak. And then one last issue that's really not related to this, but I wanted to bring to your attention, is in the situation where you're using expired listings and you're getting a hold of them. First of all, you got two problems there. I think we've talked about it in the past. Number one, MLS Rule 12-1 makes it very clear that the purpose of the multiple listing service is to exchange information about property that's available, not to provide you with information that you can use to phone call people that have had expired listings to get them to list with you. It's not a proper use of the MLS. Secondly, and if you get caught, you're gonna face a fine. Secondly, if you're calling people that you don't have permission to call, it's conceivable you could be violating the federal do not call list. Well, that's it for today. Let me tell you what's going to be happening in the future. I'm recording this on September the 12th. So the legislature is busy enacting rent control ordinances. They're busy enacting ordinances dealing with sexual harassment and independent contractors, and dealing with how realtors will fit within one of those exemptions. And so a lot's going to be coming up on new laws between now and the end of this year. There's going to be a new residential purchase agreement coming out at the end of 2020, in December of next year. We're going to be having an awful lot of discussions, and so keep an eye on these rants. As things come up, I will address them as best as I can, either in a formal class or on this program, and we'll keep you posted. Some other exciting news: I now have my own coffee cup. So hopefully you'll enjoy seeing that cup. It will be here all the time. Thank you for watching this program, and we'll see you next time.